Good morning. We have four cases on calendar that are being submitted on the briefs. Those are 23-1162, Felipe Gonzalez versus Pamela Bondi, 23-2258, Miguel Salgado Gonzalez versus Pamela Bondi, 24-5650, Kenneth Paul Hogus versus Frank Bisignano, and then 25-872, Melanie Beauchamp versus Mary Kate Flaherty. In accordance with the respective orders previously entered on the dockets of those four cases are hereby submitted on the briefs. So we will proceed with argument in the first case on calendar for argument this morning, which is 24-1092, Juan Antonio Perez Garcia versus Pamela Bondi, and we'll hear first from Mr. Stender.
Good morning. May it please the court, Chris Stender on behalf of Juan Antonio Perez Garcia. I'd like to reserve 1 minute of my time for rebuttal. Patel v. Garland does not limit this court from taking notice of evidence that is established in the administrative record. This court has jurisdiction over the case for 5 reasons. 1, because the proper standard of review is de novo for legal issues. Supreme Court precedent favors it. 3, due process requires it. 4, judicial and administrative notice permits it. And 5, voluntary departure can be reviewed by this court if legal issues are presented.
What makes it a legal issue here? Because it looks like an egregious factual error. The BIA made a statement which we all know is directly contradicted by the only pertinent evidence in the record, but that seems like a factual error.
Well, the legal requirements in order to be eligible for voluntary departure by statute and regulation require the payment of a voluntary departure bond. So that is a legal requirement in order to be eligible. The judge ordered it, and it was paid. So while there's a factual issue of whether or not the bond was paid, that is an element in order to be eligible legally for voluntary departure.
But the BIA correctly understood what the standard was, and it applied it to the facts. It just got the facts wrong.
Right. And
counsel, was there a determination made by the BIA? I mean, I think there's a difference between sort of the facts and Patel that talk about the agency sort of reviewing conflicting evidence on both sides and ultimately making a determination. Here, it really is just a mistake or an error. I don't read what the BIA did to have been a factual determination.
That's our argument. We would agree with that. There's just, I don't think you can read Patel v. Garland and say that the court should ignore evidence that's in the record. It's in the administrative record. The statute itself requires this court to make its determination of eligibility based on the administrative record.
So let me ask you this, and I'm going to ask your friend on the other side the same question. If the legal requirement is that a bond be paid, and the IJ clearly required that petitioner pay the $500 bond within this period of time in order to be eligible for voluntary departure, but then the BIA denied relief based on the failure to timely submit proof. What do we do with the fact that the BIA sort of changes, putting aside for a moment that it's factually a mistake, the whether or not the bond was paid timely, there's this sort of layer of additional requirement that the BIA imposes, which is that there needs to be a timely submission of proof of the payment of bond when the legal requirement, I think, as you noted, is simply to pay the bond.
Well, there is a regulation that talks about that in 8 CFR 1240.26C3 Romanet 3.
Can you say that again, please?
Yes, I'm sorry if that's too fast or lengthy. 8 CFR 1240.26C3 Romanet 2. I'm sorry. That says, I'll quote it, an alien who has been granted voluntary departure shall, within 30 days of filing an appeal with the board, submit sufficient proof of having posted the required voluntary departure bond. So it is a requirement, at least a regulatory. I think it's also a statutory requirement because obviously the statute talks about voluntary departure bonds.
Is Flores Molina, which also was decided in 2022, which indicates, quote, where the BIA does not consider all of the evidence before it, either by misstating the record or failing to mention highly probative or potentially dispositive evidence in its decision, is legal error and cannot stand. Isn't that a better case for you in characterizing this as a legal error?
Could you repeat the question? I'm not quite
Sure.
sure I understood the question.
Flores Molina,
Right.
which is 37 F4 626 at 632, states, misstating the record or failing to mention highly probative or potentially dispositive evidence in its decision is legal error and cannot stand. Are you arguing that that's the case here, that this was in fact legal error, and that case supports your position?
That's exactly what I'm arguing. Yes, that's true. And I think Judge Corman's concurrence in that case speaks about it at 640 and 641. And he cites to Guerrero-Lasprilla that says if you have settled facts and you're going to the law, then it's a de novo review and it's something the court can get to.
But what's the line between failing to consider or to accurately describe the evidence and a factual mistake that's unreviewable under Patel? Because one of the points that Justice Gorsuch made for four justices in dissent in Patel was that there was an egregious factual error, and that was that the agency had thought that in making a credibility determination about Patel in that case, that he had an incentive to lie on the driver's license form. In fact, that was admittedly false because he was eligible for it regardless of whether he checked the citizenship box. And so Justice Gorsuch said there's an egregious factual mistake, clear misrepresentation of the record and the decision, and yet the majority said it is not reviewable. So what is the line between an erroneous, clearly erroneous factual determination, review of which is barred by Patel, and a legal error of failing to consider or accurately characterize the record?
Well, I think in Patel you have testimony, you have weighing of evidence, you have truthfulness, you have issues there that the court has to kind of get into the weeds and weighing what kind of evidence it is. And here I think you have a bright line because you have proof in the administrative record, which this court, through statute, is required to consider in making its decision. So one way you could distinguish it is that you have evidence in the record that the government itself agrees it's in the record and recommends that this case be remanded for that. So nobody's arguing that factual issue is not in the record and the proof is not in the record. Judge Gorsuch, one of my favorite justices of the Supreme Court, in footnote number 3, points to Supreme Court precedent from 1987, and he says in Colorado National Bank versus Commissioner, states that it's settled law that findings of fact made by an agency will not be disturbed on review if it is supported by substantial evidence. But whether there is substantial evidence to support a finding is a question of law.
But that proposition, if taken to its logical conclusion, as the dissent urged, would overrule Patel on its facts, because the substantial evidence test is whether or not any reasonable fact finder would be compelled to reach the conclusion. That's the review of fact finding that is barred by Patel. So Patel bars the application of that substantial evidence standard in reviewing factual issues. So it can't be that every substantial evidence determination is a legal question because then there's nothing left of Patel. So that's what I'm struggling with. I understand the clarity of this situation, but where is the line? Because we have to draw a line. If you want to prevail, we have to draw a line that leaves something left of Patel. We can't overrule Supreme Court decisions, but that nonetheless puts your case on the other side. And I'm looking for your argument as to how that line should be drawn.
No, I agree. And I think I spoke, I hate to use the term, but I understand the slippery slope, and I did struggle with this in coming up with the argument. I think I would try to lay down a marker in that you have evidence in the record and you can't ignore it. The statute requires you to consider the evidence in the record.
Is there anything to be made here of the fact that there wasn't any consideration of conflicting evidence. It seems to me that in Patel, whether or not it was a grave factual mistake or error, there was arguments on both sides in terms of the conflict of evidence that the court ultimately weighed. And here, that wasn't the case. There was, and as you noted, the government concedes that the evidence was in fact in the proof of the payment of bond and the actual payment of bond are undisputed. So is that perhaps where the distinction may lie?
Yes, I think it's a good place to that it could lie there. I think what's kind of interesting about this case is the payment of the bond is something that happens outside of court. The judge doesn't confirm it. It gets paid, and then it gets filed along with the notice of appeal. It is a regulatory and statutory requirement that kind of something that takes place outside the court that a judge, there are no arguments made whether or not it's done, right? It's either you did it or you didn't do it. It's kind of a cut and dry issue. It was done here. It's in the record. And I don't think you can read Patel to say that the court should ignore evidence that all the parties agree is in the record. There's no dispute on it. There was, I think, a dispute in Patel. There's not a dispute here. It's in the record, and it's unequivocal. And I think for that reason, this case should be remanded to the BIA, at least for the application of voluntary departure, which was denied.
We've taken you over your time without questions, so I'll give you the 1 minute you requested for rebuttal.
Thank you, Your Honor.
All right. We'll hear now from Ms. Pham.
May it please the court, Nancy Pham for the Attorney General. Your Honors, the court should deny the petition for review in full. First, substantial evidence supports the agency's determination that petitioner failed to establish exceptional and extremely unusual hardship to his qualifying relative. And turning to what this court is most interested in, the second issue, this court lacks jurisdiction to review the agency's discretionary grant or denial of voluntary departure.
Did you make that argument, counsel?
Your Honor, in response to the court's August 28th order, the government has reconsidered its position from briefing in light of Patel.
I mean, this court either has jurisdiction or doesn't have jurisdiction. It is an issue that we need to decide regardless. But I find it a little troubling that the government is making an argument now that is a complete 180 from what it said in its papers.
And you can't say that it was in regards to Patel. Patel was decided in 2022, correct?
Yes, Your Honor.
Okay, so suddenly you just realized that Patel was an issue 3 years later?
Your Honor, I think in this case, respondent is sort of struggling and grappling with the same issue that the courts have been discussing, which is that the record seems to indicate that petitioner did file timely proof of his bond payment, and that seems to be, a factual overlooking of a fact in the record. At the same time, we have the precedent in Patel, which clearly states that federal courts lack jurisdiction.
Let me ask you a hypothetical. Suppose that there's an entire category of evidence in the record, and it's clear from the BIA and the IJ's decision that they declined to consider the evidence at all. Is that a legal question?
Your Honor, I think that it would turn on what the relief or basis is at play in the case.
Suppose that it's otherwise within a determination that's on the statutory list at issue in Patel. Is that a factual issue or a legal question that the entire category of evidence was declined to be considered by the agency in making the factual determination? Would that be a legal issue?
Your Honor, I think that is probably heading more towards the legal issue lane. But even still, with that line of question, Your Honor, Wilkinson v. Garland discusses basically when there's application of facts to a legal standard.
And there's just a complete conscious disregard. So what's to stop an agency in the next case from just consciously disregarding, ignoring facts that are undisputed in the record, or perhaps, as your friend on the other side said, a fact that they don't even have to make a determination about because it's a zero-sum thing. You either did it or you didn't do it. What's to stop an agency from just disregarding that, because the law, I think, as you're arguing now, is that always will deprive us of jurisdiction because it's a factual determination?
Yes, Your Honor. What's preventing the courts from doing that is just, their duty to carefully review the evidence and for the duty.
Did that happen here?
I can't speak to what the board did or did
Well,
not do
you agree
here.
that there was, in fact, a bond that was paid, correct?
Yes, Your Honor.
And you also agree that there was timely proof of the bond, correct?
Yes. the
Okay,
record
so was
does
there a
support that.
careful review of the record to determine whether or not a bond was timely paid and proof was made?
Your Honor, I can't speak to what the board did here. It does look.
You have to speak to what the board did here. You're defending its decision. That's your job. So tell us how we put this into the legal framework. You can't say you don't have to decide it. We have to decide this case, and we're looking for your assistance.
Yes, Your Honor. The board does appear to have overlooked this piece of evidence, and it's.
So why doesn't that squarely fit in with what we said in Flores Molina when it does overlook it? And Flores Molina was decided in June 22. Patel was decided in May 22. So it was a month later. They clearly know what the Supreme Court has said in Patel, and they there said, when you forget to review certain information, that's a legal error.
Yes, Your Honor. Flores Molina was decided after Patel, but if you look at the case itself, it does not mention Patel at all, nor grapple with Patel's holding. And I understand that might be an uncomfortable position in this case, but Patel clearly holds that there's no jurisdiction to review facts found as part of discretionary relief under 1254A2 Bravo. And what was going on in Flores Molina?
But a factual finding can have predicate legal issues that underlie it. And so the example I started with was you decline to consider a category of evidence, or you have an evidentiary ruling, and I say I won't look at this type of evidence. That evidentiary ruling can be reviewed as a legal error, and a factual finding that it rests on that could topple as a result, correct?
Yes, Your Honor, potentially, yes.
And so here, why shouldn't we read this record as follows? That the agency has told us that it failed to consider all of the evidence in the record because it's impossible for it to have said what it said if it had done so. And therefore, it categorically failed to consider some of the evidence in the record, so it wasn't making a judgment in the sense that Patel discusses, but was making the legal error of failing to consider all of the evidence in the record, and therefore it's a legal question. Why is that analysis wrong?
Your Honor, because this is a purely factual question. There's no legal analysis. I believe my friends called it a bright line, a cut and dry issue. The petitioner either paid the bond timely and gave proof of that, or he did not. And in Patel, as Your Honor mentioned earlier, in the dissent certainly acknowledges.
Suppose the BIA decision said we didn't look at that document that's at AR 35 and 36 or whatever the page number is. Suppose they said that in the decision. We did not look at it, and here's our factual finding. Can we review that? Is that a legal error in failing to look at that document?
Your Honor, I would still say that that's a factual determination.
How is that factual? How is that different from excluding evidence under an evidentiary rule?
It's different, Your Honor, because basically Patel acknowledges this and says that, the factual findings, as uncomfortable as it may be, they are unreviewable.
The
and this
factual
court must be
determination
assured
in
of its
Patel was a credibility determination. They were weighing conflicting evidence to make a determination. You acknowledge that the facts in Patel are different than the facts here, correct?
Yes, Your Honor, but what the decision in Patel turns on is whether the petitioner, whether the driver's license required him to have citizenship. And that's what that credibility determination really came down to.
I mean that might have been part of it, but there was a determination made about whether or not he had inadvertently or mistakenly checked the box or intentionally checked the box. Correct?
Yes, Your Honor.
But there's
If
a
I may-
difference between looking at all the evidence. Here's my question. Explain to me why there's a difference between looking all the evidence and then screwing it up, which is what happened arguably in Patel, and not looking at all the evidence.
Your Honor, I think the weighing of evidence and sort of screwing it up, as you put it, is more along the lines of legal error.
But
that would
to
be
weigh the
reviewable.
evidence, it has to be put in the scale. What the BIA has told us here is that they didn't put this in the scale.
Yes, Your Honor. May I, if I may, I see that I only have a minute left. There are 2 points that aren't in our brief that I would really like to make about Flores-Molina.
All right.
Flores-Molina is distinguishable from what we have here because the relief at play there, humanitarian asylum, is not enumerated in 1252A2B. So it is under Patel out of what would be unreviewable. So that's the first point, Your Honors. And the second is that in Flores-Molina and this case that they cite, Cole, what's going on there is the underlying CAT relief. And CAT relief itself is not discretionary relief by statute. And in addition to that, the court in Cole specifically mentions that the regulations implementing CAT explicitly require the IJ to consider all evidence relevant to the possibility of future torture. So the underpinning of CAT in those cases in Cole and Flores-Molina, that is what is driving the decision and the ruling of legal error there. And here we have a factual, admittedly, the record appears to show a factual error. And as uncomfortable as that may be under Patel, this court has no jurisdiction to review that factual finding. And under Riley v. Bondi and Figueroa Ochoa, this court must be assured of its jurisdiction, at the start. And if there are no further questions, Your Honor.
All right. Thank you, counsel. So we'll hear rebuttal now.
Thank you, Your Honor. And just briefly, I would disagree with government counsel that this was a discretionary determination. Obviously, the BIA did not apply any discretion in denying.
I think her point was only that Patel only applies to the enumerated provisions, all of which involve ultimately discretionary judgments but have eligibility components, and that CAT and the other item at issue in Flores-Molina were not on that list. And so that was her point.
I see, but if that was not a distinction that needed to be made, then that's fine. And I think that, what's troubling, and I think to the court and government counsel is struggling with this, I don't think you can read Patel to say that the court has to be blind to matters that are established in the record. It can't stand for that. Perhaps this is the rule of unintended consequences.
But the problem is that if we had factual error review of the sort that Patel bars, if we had it, the only time we can reverse a factual conclusion is when any reasonable adjudicator would be compelled to conclude to the contrary. So we only can reverse a factual finding if it is an obvious factual error. And so we can't be the rule that every obvious factual error is a legal error gets out of Patel, because then Patel is a shell. It's gone, and we can't do that. So there has to be a line between the obvious factual errors that Patel allows to stand and what you're advocating here if you want to escape Patel.
And there is statutory support that the court has to make its decision based on the administrative record. And this is in the administrative record. So it's not just a Patel Patel situation, I think. There is, in the statute, a requirement that the court consider the evidence in the record. I think the court can hang its hat on different issues, but I understand if you want to draw a bright line, and that's what we've been discussing here at length, this is a difficult situation. But again, I just fall back
to the line you would draw is between weighing the evidence in the scale and placing the evidence on the scale.
Well said. And with that, I'll if there's no further questions, I'll I'll finish.
Okay. All right. Thank you, counsel.
Thank you very much.
Case
Appreciate
just
it.
argued will be submitted.